Am I permitted to move a lunch motion, Your Lordships? Writ petition under Surface Act, Lordships. The petitioner before Lordships is that auction purchaser, Lordships. He is seeking a time for depositing 75% of the amount. The petition pending.
All right.
I'm obliged, Your Lordship.
My Lordship, may I move tomorrow's slip for writ appeal 2024, my Lord? Leave. Excess assess has been levied, my Lordship. Notice have been issued to take coercive steps, my Lord. My request
Is this a pending matter?
my Lordship.
Is this a matter which is already pending?
Yes, my Lord.
Pending matter?
Yes, it's a file matter, my Lord. Writ appeal of 803 of 2024,
No.
my Lordship.
Is it a matter which is already pending or a fresh matter?
It's filed, my Lord, but last time before vacation it is listed, my Lord, but it did not reach, my Lord.
So when do you want?
Tomorrow, my Lord.
All right, tomorrow.
May I please write? Matter pertaining to the Surface Act, my Lord. And the same matter connected matter is becoming on 16th, Your Lordship. Same we have it on 16th, my Lord.
All right, on 16.
Please, my Lord.
Next to Vivek Chandrasekhar is online and lots of information.
Yes, Mr. Chandrasekhar.
My Lords, with the Lordship's kind leave, I request for listing of a writ petition tomorrow, my Lords. The urgency is this: matter arising under the Surface Act, where I am appearing for the respondent bank. The borrower has challenged a safe proclamation notice and obtained an interim order from this Honorable Court in the month of January 2024. And he's continuing to enjoy the benefit of the interim order. He's also approached the Honorable DRT challenging the very same proclamation of sale.
So what is the
He's writing
date?
two horses at the same time.
What is the date fixed
I'm
in
sorry,
the
no?
case?
Date fixed was on 1st of October, my Lords, for hearing.
So we'll have it next week.
Very well, very well.
Give the list on any date next week.
Connected writ appeal is
Obliged.
connecting tomorrow. Connecting writ appeal is coming tomorrow, madam. Fresh writ appeal.
This is a fresh appeal.
Yes, madam. 3 more appeals coming tomorrow.
All right, list tomorrow.
I believe, Your Lordship. The registration authority is not registering the sales certificate, Your Lordship. Matter is posted directly to listed on 13/9, Your Lordship. After that, not listed, Your Lordship. Kindly have it in this week, Your Lordship.
Next week. Next week.
My pleasure, Your Lordship.
This criminal petition, Manoj, are filed IA, Manoj, seeking relaxation of conditions. Manoj, the section, Manoj, is taking an objection that the
How are you coming before us?
Manoj, as per the roster, Manoj,
You
that
please approach the registrar judiciary. Yes.
My request, my lords, for tomorrow. Auction is scheduled for tomorrow, my lords. We are cane farmers. We have dues pending, my lords, before. We have pending dues with the company, my lords, which is scheduled to be auctioned. My lords, our dues were not considered by the company, my lords. Lords, may I have it tomorrow, my lords. I am requesting for tomorrow. Obliged,
May I please? Item 1, my lord.
My lord, may I please, your lordship? Item 1, my lord. I request, my lord, first thing, my lord, I apologize, my lord, for non-appearance last occasion, my lord, where it is posted for dismissal. My lord, I request 2 weeks time, my lord.
All right, so we'll have it after 2 weeks. Delete from the discussion.
Highly obliged.
Yes, who's number 2?
Highly obliged.
28 to 39.
Number 2 same.
40 to 53.
Item 43, my Lords.
Who's in number 2?
May I please, Your Lordship?
Okay. Okay.
Item 43, my Lords.
Yes.
Not the impugned order is passed by the other learned judge, my Lords.
Sorry?
Impugned order is passed by the other learned judge, my Lords.
Okay. So list before a bench of which one of us, Chimlapati J, is not a member. Yes.
54 to 66.
that's item 55, Manoj. Manoj may take it up after 2 weeks, Manoj.
You are for whom?
Manoj, I'm for the petitioner, Manoj.
Petitioner?
Yes, Manoj.
All right. Adjourn the request. 6 weeks. Next.
Obliged, Manoj.
67 to 77. Item number 2, K. Varun Kumar.
Please, Your Lordship. My sincere apologies, Your Lordship. On the last occasion, I couldn't appear, Your
All
Lordship.
right, so list after 2 weeks, delete from the dismissal column.
Much obliged.
Yes.
May it please, my lords. My lords, the writ appeal is directed, my lords, against the order, my lords, of this honor of the learned single judge dated 26/9/2024. My lords, the respondent corporation in the writ petition, my lords, is the appellant before your lordships. My lords, the termination of a retail outlet, my lords, was impugned before the writ court. My lords, the termination was on the ground that a third party unauthorized person is, my lords, running the retail outlet. So the writ petition now is filed by that third person without any locus standi, and with whom I have no dealership agreement. The termination proceedings are also not addressed to that gentleman. And this third person, my lords, to prove my point, my lords, files the writ petition, and an order of status quo is granted. Now kindly see, my lords, the dealership agreement at page 32. I'll just draw your lordship's attention, my lords, to page 32. Page 32, my lords, your lordships will find the first para itself, my lords.
Dealership agreement was with whom?
My lords, with the second respondent in the appeal, Putteti Surendra Reddy. Now this gentleman is the sixth respondent in the writ petition.
And there cannot be any interest created in the dealership.
Dealership without the permission of IOCL.
Okay, so there is no permission according to.
There is no permission.
Where is that clause?
My lords, that is, I'll just, my lords, the dealership agreement at clause 35, your lordships will get it, my lords.
Yes.
Your lordship, that's at page 36.
Page 36.
Yes. The
Which,
dealer shall not,
Page 36, but which clause?
clause 35.
All right.
The dealer shall not sell, assign, mortgage, charge or part with or otherwise transfer his interest in the dealership or any right or interest or benefit conferred by this agreement of grant of any license in connection with the said premises and or outfit or any part thereof to any person, firm or company, nor allow any other person, firm or company to use the premises or the outfit or any part thereof except to the extent necessary under the terms of agreement and specifically permitted in writing by the corporation.
There is no such permission.
There is no such permission. Kindly see the notice for, show cause notice for termination, my lords. I'll just draw your lordship's attention, my lords, as to whom it is addressed to. That's at page 110. The show cause notice for termination, my lords, is at page 110. It's dated 11/5/2024. Your lordships will see the name, P. Surendra Reddy.
So this unauthorized person files the petition challenging this show cause notice?
Challenging the termination proceedings issued in pursuance of this show cause notice. The termination proceedings are at page 117.
So it was terminated.
Yes. 16/9/2024, page 117, my lords.
So does the termination order say that this was unauthorized?
Yes.
Where do we see?
Kindly see, my lords. I'll just read out, my lords. It should.
Yes.
You have been operating our A-site retail outlet. I'll just clarify, my lords. A-site retail outlet would mean that the IOCL owns the land or leases the land. The land, my lords, belongs to IOCL. In this case, this land is owned by IOCL. That is what A-site would mean. We have been operating our A-site retail outlet in the name and style of Messrs. Sri Satya Oil Filling Station at Chilakuru in SPS Nillar district, wide dealership agreement dated 27/7/2001, executed between IOCL and yourself for the sale of motor and high-speed diesel and other petroleum product. Whereas you have submitted dealer annual return for the financial year 2018-19 on 11/5/2020. After verification of the DAR by our field officer, following observations was recorded.
RO constitution as per dealership agreement is proprietorship, whereas PAN uploaded is in the name of Sri Satya. The name of the dealer as mentioned is DAR is Voveti Sugunakar Reddy. Whereas dealership agreement and records available with the corporation, the name of the proprietor is P. Surendra Reddy.
What is DAR?
Dealership and dealer annual return.
Dealer annual return.
Yes.
So this is being filed by the petitioner,
Yes.
the third party.
Not by the third party. Until 2018, my lords, it was filed by the petitioner.
This, no. So the dealer, the authorized dealer.
Yes.
So this Sugunakar Reddy is the authorized dealer?
No. He is the third person.
He is the third party. So in the annual return, this third party's name gets reflected.
For the first time in 2018. Well, subsequently, what has happened is, in dealership annual return of 2021, which was submitted, my lords, in 2023, the name of the entire dealer, the original dealer itself is not there. This Sugunakar Reddy and another third person's name is recorded. I just point that out, my lords. The lordships will see serial number 2. The name of the dealer as mentioned in DAR is Bobeti Sugunakar Reddy. Whereas dealership agreement and records available with the corporation, the name of proprietor is P. Surendra Reddy. In the balance sheet for financial year 2018-19, capital account holder's name is mentioned in the balance sheet is Sri P. Surendra Reddy and V. Sugunakar Reddy as partners. As per dealer's bank letter dated, the retail current account in State Bank Gudur is being operated
that means Surendra Reddy incorporated Sugunakar Reddy. That is permissible.
Yes, without my permission.
No, that's all right. So, does the dealership agreement permit?
It does not. That is the violation that is
permit an authorized dealer to enter into partnership?
It does not, my lord. So, the only possible scenario is under clause 35 with the permission, my lords, where the dealer himself would file a reconstitution application, and then the reconstitution application, my lords, while naming the new partners, would be approved by the respondent corporation. Only then he can bring in new partners.
Where is that clause?
The clause 35, my lords, in this agreement only, at page 119, your lordships will find it. In the termination order itself, it's given, my lords, in bold letters.
No, when a dealer enters into a partnership agreement, does it amount to sort of transferring his interest in the dealership?
Yes, because there are two reasons, my lords. It would give him the right to obtain fuel, my lords, from the Indian Oil Corporation.
Where is the clause with regard
clause
to...
Clause 35, my lords.
No, that is all right. Where is the clause with regard to permitting him to enter into partnership?
My lords, your lordship may kindly see page 119. My lords, the termination order itself has all the clauses which have been violated.
No, but let us go to the agreement.
Yes.
And see, is there any specific clause which authorized him, although with the permission of the...
Yes, that page, the clause 35 itself has that specifically permitted in writing by the corporation.
Where is that?
Clause 35, page 36.
35 does not talk about specifically about permitting him to enter into partnership.
Your lordships will see, Millers. The dealer shall not sell, assign, mortgage, charge or part with or otherwise transfer his interest in the dealership or any right or interest or benefit conferred by this agreement of grant of license in connection with the said premises.
So the question is that when you enter into a partnership, you are not parting with your interest in the dealership.
Miller, subsequently what has happened
Does it amount to parting with the interest in the dealership?
In part.
You only bring in a partner who may sort of infuse some funds with a view to enable the smooth functioning of the outlet.
Kindly see, Miller's clause 45 as well. Same page 36, clause 45. It shall be paramount condition of the agreement that the dealer himself, he be an individual, or both partners of the dealership firm, if the dealer is a partnership firm, or the majority of partners of the dealer firm, if the dealer is a firm consists of more than two, majority of powers, as the case may be, page 37, shall take active part in the management and running in the retail and shall personally supervise the same and shall not under any circumstance do so through any other person or firm or body.
This is only a status quo order.
Miller's, the issue is, subsequently the dealer
let us
himself
see.
went out of this scenario.
1 second, let us see what has the court held.
The court, Miller's,
Let us read the order.
yes, the impugned order, Miller's, your lordships will get at page 7.
Yes. Heard counsel for the petitioner.
Yes. Page 7, Miller's, it starts. Page 9, learned, heard learned counsel for the petitioner and learned standing counsel for respondent 286. Learned counsel for the petitioner submits that fifth respondent entered into a agreement with sixth respondent on 27/7/2001, appointing sixth respondent as dealer for retail sale and supply of petroleum products at Chilkoot town under the name of style. As per the terms of the agreement, the sixth respondent continued the business for a period of 5 years. Due to personal problems, the sixth respondent was unable to continue the business, and hence on 28/4/2006, sixth respondent entered into a partnership agreement with the petitioner for running the business. This partnership agreement I am not aware of. Since then, the petitioner has been carrying the business as a dealer on behalf of sixth respondent. This is admission, my lords, that the dealer is completely out of the picture. Learned counsel for the petitioner submits that the fifth respondent addressed a letter dated 19/9/2018 to the petitioner, intimating there was a deviation in the dealership setup. Later, the fifth respondent issued another letter dated 17/3/2021 to the petitioner, instructing for submission of reconstitution of firm proposal for regularizing the deviation in the dealership setup. Thereafter, on 4/9/2024, the petitioner submitted an application for reconstitution of dealership. While so, the fourth respondent issued a show cause notice dated 11/5 to the petitioner. This is not to the petitioner.
So you do one thing.
Obliged.
Why don't you file your objections and seek vacation of the order?
Miller's, the issue remains
Because
only
it will
one thing.
amount to judging an issue by a division bench when the matter is still before.
Yeah, I'm only seeking, Miller's, my basic.
So he has been already, you see, running the show for the last about 5 years now.
Miller's,
Not 18,
not
18
5
years.
years.
18
I'll
years.
complete, I'll complete. Now an IA is filed. I'll just complete, Miller's, as to why this is important.
So let us not, you see, because there will be nothing left to decide by.
Miller's, I'm only seeking a remand, only on this ground. The primary preliminary objection of locus standi is not considered. He is, Miller's, misleading the court by saying that every correspondent is addressed to the writ petitioner. It is not. I have demonstrated before this honorable court. The land belongs to me. He has filed another IA, Miller's, before the single judge, learned single judge, where he says that supply of fuel should be done to him. It will, Miller's, I have zero supervisory control over him. There is no agreement with him. He admittedly, Miller's, is running the bunk, and the main dealer is clearly out of the picture. If something untoward happens, Miller's, it is my reputation that's on the
Nothing
line.
prevents you from approaching the Leonard single judge. This was an ex parte order.
Miller's, I made my submissions, Miller's, but
Corporation was heard.
yes.
Both sides.
But only, Miller's, my locus standi argument was not dealt with, Miller's. The issue of locus standi is very important in the sense that my case is that the third party is running it. Miller's, the third party approaches this honorable court, admits that he is running the retail outlet without the permission of IOCL. And that is why the termination proceedings was issued. The termination proceedings itself, Miller's, were addressed to the original dealer, who is the respondent.
Have you filed your counter affidavit?
No, Miller's.
So you file your counter affidavit within 1 week, we'll direct it.
Miller's, kindly see the second IA, Miller's, that is filed on the same day I filed my writ appeal.
What is that?
Miller's seeks that fuel be supplied to him. I can't supply fuel. Status quo order itself is impacting me because the land is owned by.
There is no order passed in that IA.
No order is passed.
So then there is no obligation. Then why are we then agitating?
In that
this?
case, your lordship may at least clarify.
No. So you go before the Leonard single judge, will direct its listing next week, file your objections, and argue the matter.
The issue of
The
locus
present
standi.
latest patent appeal has been preferred.
May I just make one submission? The supply of fuel may be subject to Miller's me filing the fuel. I cannot supply the.
There is no order for supplying fuel to him. In the IA filed by him
Miller's,
subsequently.
the IA Miller's, in the affidavit, he says that status quo would mean that I have to supply fuel.
That's a
to-
different thing. So you go before the Leonard single judge. The present letter patent appeal has been preferred against
Item number 4, case inverse.
May I please?
Yes, what is this?
This is Milad challenging the 13-4 notice. Petitioner is a third party, Milad. Second respondent Milad obtained loan from first respondent, who is deceased now. Milad, entire amount was paid by the Milad, this appellant before your lordship, through Milad, through his account, loan account. But the bank issued
one. Who is the principal borrower?
Principal borrower is Milad, second respondent.
Siva Granites.
Yes, represented by Milad Bommireddy Shankar Reddy.
And who are you?
I am the purchaser of Sivasai granites from second respondent.
You have purchased number 2?
Yes, Milad.
So,
entire amount was paid to the bank.
By the petitioner?
Yes, Milad.
Then,
even then, they issued 13-2 notice and 13-4 notice.
Yes.
I approached this honorable court, this honorable court directed the bank petitioner, page 85, it starts.
Page
85.
85.
Yes,
Yes.
Till 86 till the disposal of the objections, there shall be no coercive action against the said property. This was the order passed by this honorable
Court
court.
deems it appropriate to dispose of the petition, leaving it open to the petitioner to file objections.
Yes, I filed objections.
So?
Even then, Milad, they issued 13-8 notice.
No, after objections are filed, they would have considered and rejected.
They are not considered as on today.
We
This
don't
order
know.
was passed, Milad, on 2nd May
You can
2024.
go before the DRT then.
No, I am a third
This
party.
is not a,
I am third party, Milad, because I could not
third
approach.
party, but against whom was the notice issued?
Notice issued to the second respondent by the first respondent.
Granites.
Yes, Milad.
So you can go before the DRT. Any person under section 17 can go before the DRT.
But Milad, even then there is an order by this
The
honorable
question
court.
is, objections have been filed by number 2,
Yeah.
Sai Granites. Did they file the objections?
No, they have not filed. I filed objections. I have filed objections. That is also, Milad, I have placed before this, page 26, Milad.
So very well. So they can go, brother.
But now they are
Nothing
taking steps,
prevents.
Milad, may make one submission. Now they are taking steps, Milad, but taking position of the petitioner property.
To do, you should have worked out your remedies. Take down. The time you rushed to the DRT. Yes.
Yes, Your Lordship. This is surface case, Your Lordship. Your Lordship, the petitioner is purchased the issued property from the fourth respondent, who is the real borrower from the bank. So,
One second. So, who's the, this is, you purchased it from?
fourth respondent in the year 2019.
All right.
So, in the year 2020, I sold that property to fifth respondent. So, later I came to know the fourth respondent borrowed the 10 lakhs rupees for a house loan from the respondent number 1 bank. The bank people filed a suit against me and
What was the asset?
house.
It was a house.
It was a house, a small house. Now, the point for consideration is the bank people filed a civil suit before the civil court and obtained a decree, and they filed final decree. Now they came forward and filed a section 14 petition before the Chief Judicial Magistrate.
Yes.
In fact, Your Lordship, I am contacted the banks with negotiated. Now, I would like to pay that amount, demanded amount, 9 lakhs, page number 44, that is the demand notice, page number 44.
44.
44 is demand notice. In page number 45, the total outstanding amount was mentioned.
Oh, this
9
is 23. This is 1123. How much was the amount then?
Oh, the 9 lakhs 34,000.
How much is the amount due today?
Later, I paid 1 lakh rupees, Your Lordship.
You
That
paid
is,
1 lakh.
That is on 47 and 48
But that
receipts.
is not enough, no? That is not enough.
Now, I am ready to pay. I am negotiate with bank people. I am willing to pay that entire amount with 6% interest as per the award given by the civil court. But the bankers are refused. They have demanded me to pay additional charges and everything. And hence, I approached this honorable court to stay the orders of the Chief Judicial Magistrate Court and allow me to deposit the 9 lakhs 34,000.
As per the civil court's decree, how much is the amount payable?
9 lakhs 34,000, Your Lordship.
Along with interest, 6% interest.
6%.
How much does it come to?
It's come roundly, it comes 11 lakhs maybe.
11 lakhs. So you are ready to pay 11 lakhs.
I am ready to pay 11 lakhs.
So
And
who's for the bank?
State Bank of India.
Who's for the bank?
Notice will have to go. Your Lordship.
Huh?
Notice will have to go.
Notice will have to go. So you deposit 11 lakhs?
Yes, I am ready to deposit.
But is the amount which is payable to the bank, according to the bank, more than 11 lakhs? Is the amount which the bank claims as against the property more than 11 lakhs?
They demanded me for payment of 14 or 15 lakhs.
14 or 15 lakhs. So
they calculated all the surcharges
whatever.
and
So if you want to save the property, but you have already sold the property.
I sold, but it is a moral obligation for me. I sold the property to fifth respondent. It's a moral obligation.
So you
Later,
do-
I want to recover the property from the real borrower.
Okay, so you deposit 14 lakhs by tomorrow?
11 lakhs I will deposit, Your Lordship.
11 lakhs?
14
no.
lakhs means there is no case. They are bank people also agreeing.
No, you deposit the entire amount which the bank claims is outstanding, then we can stay.
That is 44.
Generally, we don't stay.
That is page
But,
number 45, Your Lordship.
But if you show your bona fides that you will...
Page number 45, it was mentioned 9 lakhs 34,000. I will pay, ready to pay that amount immediately.
You deposit 14 lakhs, then we will see. We will then issue notice and work out how much is due and payable.
Your Lordship, I am ready to pay 11 lakhs.
How much did you sell the property for?
Property will go right today 20 lakhs.
what is the sale value in the deed executed in regard to the property with number 5?
They have not mentioned.
How much was the property sold for?
It was not mentioned in the notice, the value.
How much amount you sold the property, the chief is asking.
To number 5,
Oh, 10 lakhs.
10 lakhs.
10 lakhs. It was mentioned in page number
So
30.
another 20, add another 20 to it.
What?
Add another 20 to it.
No.
So you deposit 14 lakhs. Say notice returnable in 2 weeks.
Item number 6, where the borrower?
May I please? Additional student, my lord, he appeared for the NEET 2023, my lord. My lord, he was allotted a seat, my lord, but at the same time, the AP counseling, in the AP counseling, he is not appeared, my lord. When in 2024 NEET, my lord, he appeared, my lord, and also obtained a rank, my lord.
Well, one second.
Notice.
So you are a student who had appeared for NEET PG?
Yes, sir.
You cleared?
Yeah.
Did you apply for?
Counseling applied, my lord, now they are
applied?
not. Yes, applied, my lord. Fee also paid, my lord, pays 36, my lord.
So you were allotted a seat?
Lord.
Were you allotted a seat?
It is not I am requesting, my lord, to allow me for counseling, my lord.
So why are they preventing
They
you from?
prevented, my lord, the 2023, my lord, he appeared, my lord. But, my lord, he is not joined, my lord, because same time in the AP.
So if you do not, if you are allotted and you do not join, you are prevented from
Yes,
participation afresh.
Participation.
Where is that clause?
Clause, my lord, page 27, there is a notice, my lord, has given, my lord.
Page 27.
27 notice. Third para, my lord.
What does it say?
In view of above, following is the list of PG 2020 candidates who were allotted seats in stray vacancy round and special stray vacancy round but did not join in the seats. Accordingly, the candidates mentioned in the list will be ineligible to participate in the counseling process of PG counseling 2024.
Okay.
The candidates will be debarred before seat possible.
Your name is listed in this? Your name is mentioned in this list?
Mentioned, my lord, mentioned, my lord, I also paid fee also, my lord, as per the directions, my lord.
Huh? Where is your name?
Name is not.
How do you say that you fall under this
Notice,
category?
my lord.
Then where is that
Tell
rule?
notice, my lord, they.
Where is that rule? Which,
Rule, my lord, page 20, my lord.
Page 20.
Page 20. Page 20 E, my lord, call. If a candidate is allotted a seat in stay round, he shall ask to report and join the allotted seat, public college, else he shall be debarred from NEET PG examination for subsequent 1 year along with forfeiture of security deposit.
So then how do you then overcome this?
My lord, due to the, my lord, in the same time, my lord, in the Andhra Pradesh, my lord, counseling is going. I am waited for that, my lord, but they are not conducted the counseling in time, my lord. Therefore, my lord, I am not able to report there, my
Who
lord.
did not conduct the counseling on time?
In Andhra Pradesh counseling, my lord. In same time, my lord, the same time, my lord, the same counseling is going on here, my lord. For my lord, I am waiting for this, my lord. Therefore, my lord, I could not report the earlier counseling.
Chief is asking, and you have not participated in the stray vacancy.
He was allotted a seat and he did not come forward to take the seat.
Taken the seat having paid the amount.
My lord, because of, my lord, I am waiting for the AP counseling, therefore I could not join, my lord.
were selected for which,
Milord,
under
the
this,
Darbhanga Medical College, Bihar, Milord.
against the All India quota.
Yes, Milord, all India quota.
So say so.
Yes.
So, because you did not take the seat in the All India quota, you are prevented from now applying for the
Yes, Milord.
state
Yes.
quota.
Yes, Milord.
What do you say?
I am appearing for the fifth respondent, my lord. The papers are not available with me. But I got instructions, my lord. The petitioner, having availed a seat, not wasted 3 years not without joining in the.
So then that seat got filled up, the one which was
No, my
allotted to
lord.
him?
That is got wasted. And,
That got wasted?
Yes, my lord. And the candidate, my lord, petitioner, she specifically, my lord, undertook abide by the conditions. Lord, this is the notice, my lord, which is not filed by the petitioner counsel.
So then, if there is a specific rule which prohibits you from getting considered, how do you overcome? Have you challenged the rule?
Notice.
You have not challenged the rule. Then how do you succeed then? How can we issue a mandamus? Which is the rule? This is only an extract from the
Yes, my lord. This is
information
the notice
brochure.
issued by
Where is the rule? Which rule?
They have not page 20, Milord. They are saying that final stay vacancy round, Milord. There is no such
Page
rule,
20
Milord.
is only an extract from the information brochure.
Yes.
What is the rule which governs admission?
I'll file counter, my lord.
What is the rule?
Short time may be
Rule, there is
granted.
no such rule, Milord. They are given conditions, Milord. Final stay
File your
vacancy round.
response. Notice objections in 2 weeks. Next.
My apologies, my lord. I am having to seek my lord's indulgence in permitting me to represent online today, my lord.
Yes, certainly.
My lord, this is a matter which is already pending with the court, my lord, our court. This is a challenge to 2 of the sections of a legislation passed in 2023, my lord, which is Act 35. This has been brought in by the state, my lord, to overrule the judgment of Mekala Pandu, my lord, which has been upheld by the Supreme Court by a devious method, my lord. I have challenged these 2 sections on several grounds, my lord, and I have placed copies of the judgments relevant to the case, my lord, of the Supreme Court, which make it impermissible for the state to undertake
Okay,
what
then,
it had.
so we'll admit this and ask them to file their counter.
That is already, in an earlier matter also I filed, my lord, 5727 of 2024.
Yes.
That was to be listed in the first week, my lord. This court had not functioned, my lord.
All right,
Possibly
say
my
heard,
lord.
admitted, say, counter be
5727.
filed in 8 weeks list along with connected matters. Okay.
I am obliged.
You are appearing for the respondents?
Yes, madam.
Yes.
Item number 8, T. Kiran.
Senior counsel is appearing on through online, Mr. Sriram.
Yes.
May it please your lordship.
Yes.
Well, it's round number 2 in respect of the same medical college.
So now the second appeal got, they remanded the matter?
Yes.
Yes, well, the order is at page 21.
Yes.
But somehow the primary authority may not want this benefit to pass by. Kindly see the operative portion, which could be at paragraph 10 at page 23.
Yes.
All the contentions in regard thereto have been noticed. If your lordships kindly come to page 24, 3 paragraphs atop paragraph 11, which are with bullet points at page 24.
24 is not legible, but is there a typed copy?
Yes, madam. Page number 29.
29. So on page 29, which paragraph?
Yes, my lords, if your lordship now kindly comes to at page 30. Page 30, Yes, unnumbered paragraph number 2, the bullet point. The committee observed. Lordships have.
Yes, yes, yes.
The committee observed that there were technical issues in biometric devices available in the college. The same was raised by the college with NMC in the month of April 2024. However, as informed by the college, the issue was resolved in the month of July 2024, and the faculty attendance got improved in the month of July and August 2024. Further, as informed by the college, they have a total of 168 faculty against the requirement of 141. The committee also observed that as per NMC norms, they have a total of 168 faculty against the requirement of 141. As per AEBA's records of July in 2024, they have deficiency of 10 faculty, which is 5% of total requirement and under the permissible limit. The documents and submissions made by the appellant have been considered by the central government. The central government, after due examination, has decided to remand back the case to NMC to physically assess and verify the submission of the college and to issue appropriate order at the
Mr. Sriram, this direction is to the NMC to conduct inspection. So your relief also is that they should conduct an inspection.
Yes. Now,
so now who is for the NMC?
Mr. Vivek Chandra Shekhar is appearing.
Well, I appear for the NMC.
So then, so please conduct, so this order was passed when?
Yes, this was on
30th of September.
30th September 2024. Time is of essence is something that the NMC told us in the first round, and we apprised the central government also.
So this, so why don't you conduct the inspection within a week or 10 days? So you take instructions.
I'll come back to instruction. Lordship may consider having it on Wednesday, subject Lordship's convenience.
No, but we can have it in the afternoon session. You speak to them. How, so in the team, how many members come from the NMC?
Usually there are ranging between 3 to 7, depending on, it's a random select. You have 3 assessors usually.
So generally, so those team members are already identified, or every time they have to?
It'll be a fresh allotment. They'll be picked randomly each and every time an assessment has to be done.
Generally, the members are from this region only, from the state, or they have to fly from outside the state?
They'll have to fly from outside. It can be pan-India.
Oh. So then, so if there is infrastructure and faculty, then it will be in the interest of the society also to have more trained doctors. So if you can get instructions.
If I am only request for tomorrow, Sir Lordships can.
Yesterday, a very close relation of mine fell sick in some place in Himachal. So we got a call at around 10:30 that there is problem. So we said that please take him to bring in a doctor or take him to the nearest medical facility. They said that there is supposed to be a doctor, but there is none for the last about 8 months. So there is such a great deficiency of doctors in hilly regions, you can't imagine. It is not just from the point of view of the medical colleges and those who are running it, but also the deficiency of doctors in the system. So please sensitize them and see if we'll take it up after break. Just try to get instructions, otherwise we'll have it on maybe tomorrow, but just find out whether in a week or so if they can, or 10 days if they can constitute a team. Admission may not be possible this year, but at least the groundwork will be done.
Permission is possible this year because the counseling is still going on, and the counseling is as of today scheduled to conclude only on November 5th. And if the NMC can corroborate what the central government has prima facie found on physical inspection, we may have 100 more students joining the institution this year itself if NMC acts in time.
Right. So it is in the interest of students also. They may reject if there is no faculty, or if their claim that there is faculty is found to be not correct. They may reject, but at least the groundwork can be done. And it has already been almost about a month since the Union of India passed the order.
In that case, my lord, if I'm only requesting, the Learned Senior Council has made a statement that the counselling is there November 5th.
We are not
tomorrow, Lordship may kindly consider accommodating.
We are not getting into that.
I'm only asking accommodation for tomorrow, between today and tomorrow.
All right, tomorrow.
Very good.
Yes.
Obliged.
Item 9 to 27, P. Mohan Rao, Chief Agriculture.
May it be placed, Your Lordships.
59. Earlier matter, item number 8, item 59.
Oh.
That may be posted.
This, in which Mr.
Yes,
Sriram
yes,
was.
yes.
That was the first round, that's the first round writ petition.
But
It
then
can be tagged along with
but
this.
does it survive?
That has now become
So
infructuous.
then, so dismiss as having been rendered infructuous.
Yes, all the papers have anyway been filed into this
Dispose of
matter
as
also.
having been rendered infructuous. All right.
Obliged.
Yes. Next.
May it be placed, Your Lordships. Item numbers 9 to 27, Your Lordships. All these matters are arising out of the common order passed by the National Consumer Dispute Redressal Commission, wherein the said order was stayed by this Honorable Court in the batch of writ petitions which were listed in the week before vacation, Your Lordships. May I pause on the orders, Your Lordships?
Please show. So you say that there was no storm.
Yes, Your Lordship.
There was no storm which could have led to
Yes, Your Lordship.
the liability having been created
Very
against.
pleading itself, this falls, Your Lordships, is our ground, one of our ground.
Insurance of crops, etc. They say on account of storm, they say the weather department is. This returnable in, when is this matter coming?
It was posted to 22nd, Your Lordships,
Okay. So
batch of matters.
Okay, notice returnable on 22nd of October 2024, placed along with petition number 22103 of 24. In the meantime, the order passed in, order dated 3rd of October 2024, passed in petition number 22103 of 24 shall apply on similar terms in the present petitions as well.
Much
All
obliged.
these cases.
Yes, Your Lordships.
Personal notice is permitted.
Much obliged.
Yes.
Item number 28 to 39, duty measures.
Same order?
Same order.
Same order.
Obliged. Item number 40, M. Suprabhat Reddy.
Yes.
Person, it will be correct.
Okay,
Some
pass over.
documents were correct.
Suprabhat
Yes,
Reddy.
me, yes.
Where is Mr. Who's Mr. You are the one?
I am the one.
You are Suprabhat Reddy?
Yes, yes.
So, what is this?
The enrollment number was wrongly entered in the bar ID, my lord.
Sure.
I given the complaint to register to change my. It's wrongly entered was 2513 instead of 2516. Only one number, my lord. Only TS 2513 oblique
The
2000.
order says you have two registration
Yes,
numbers.
yes, my lord. It was wrongly entered 2516, my lord.
2516 is entered where?
And last, the order was given the honorable court, my lord, in this.
So, where from did the court find this 2516 of 2013?
My colleague is appear, my lord, short.
What is this issue?
Last time, they only mentioned that there are
Who
two.
mentioned?
The council.
What?
Mr. Suprabhat Reddy, he only admitted that there are two enrollments in the bar council.
So,
So there was some, because he was not appearing in the matter, his colleague was appearing in the matter. That's when this honorable court had directed his appearance, and then he submitted.
for the bar council here?
I'm a counsel.
You are the counsel for the bar council also? Are there two registration numbers according?
I'll verify your lordship.
Counsel for the, say, so-and-so seek some time to verify as to whether whether Shri so-and-so, Shri M. Suprabhat Reddy,
I noticed the sub-register, my lord. They are verifying. As they wrongly mentioned was 2516.
Okay, no problem, don't worry. Whether the to also to this so seek some time to verify after taking instructions as to whether as to whether Shri M. Suprabhat Reddy was enrolled as an advocate under registration number so and so and so and so. These are two registrations.
My COP, my lord.
And what is the other one?
The certificate of practice, I have.
Just verify, no problem. You take it. Next week we'll have.
Kindly have it tomorrow, my lord. There is an urgency in the medical admission matter, my lord, in this same matter.
Oh, okay, tomorrow.
Tomorrow, obliged.
You can find out?
I'll find it.
May I submit, my lord, one thing, my lord? The only typographical error committed by the office.
No, there is some order passed.
Yes, my lord. Only with regard to that, I am clarifying
No,
it.
we are not
Obliged.
doubting, no problem. Yes.
Item 41, Avinash Desai.
Tomorrow, my lord.
Coordinate bench has noticed it, so we will just
Yes.
sort of clear.
Kindly have it tomorrow, my lord.
Tomorrow.
Obliged.
Ms. Pranati, you will
His
find out.
presence may be dispensed with, my lord.
No, it is good to have him as company for some time till
No,
tomorrow.
because the issue is like this, my lord. He practiced in Hyderabad.
Oh,
Not-
you have come from Hyderabad?
He practiced in
Go to
district.
Kanak Durga temple today, what is the problem? Wait till...
We obliged him a lot, but some difficulty in his family.
No, wait. Wait till tomorrow.
Obliged.
Yes. What is this?
Your Lordships are here on behalf of the petitioner in this matter, Your Lordship.
Huh? You are the petitioner?
Yes, Your Lordship. Last occasion, Your Lordships had given us time due to the counsel on record being designated as senior. We tried contacting the client, Your Lordship, in this matter, but to no avail.
So you are for the petitioner?
It may be, so the matter relates to a sale and subject property, Your Lordships.
Maybe. Now Mr. Desai has been...
Maybe infructuous, Your Lordship, is what we're submitting.
All right, so the counsel appearing vice Mr. Avinash Desai states that the matter is rendered infructuous. Disposed of accordingly with liberty to the petitioner to approach this court again in case the cause still survives.
Deeply
Yes.
obliged.
Next.
Item number 42, Sir Raghunath Reddy, PSP Suresh Kumar.
Yes, who's in this?
I am for appellate, Your Honor.
Okay, what is this? Yes.
My submission, my lord, the respondent number 1, M. Lakshmanarayana.
So the learned single judge has held that the dispute has to be raised, cannot be raised before the arbitrators, it has to be raised only by way of civil proceedings. What is the dispute? What is the dispute?
The the dispute relates to Section 61 of Cooperative Societies Act.
No, you tell us now. So what is the dispute regarding?
Dispute between the appellant and the respondent.
Okay, regarding what?
Regarding the in NGOs cooperative societies, building society in Raichoti, originally the plot was allotted in the favor of the appellant. In 1982, he became the member of the society in 78. Now,
Lot was allotted to the appellant.
I am appearing for the appellant.
No, plot was allotted to you.
Plot was allotted to me.
By whom?
By the society.
Which society? AP Cooperative Tribunal. NGO Cooperative House Building Society.
House Building Society, Raichoti.
NGO's Cooperative.
NGO's Cooperative Society.
Cooperative House Building Society.
Yes, Your Honor.
This was allotted to you in the year?
In the year
1981.
82, Mila.
82.
82.
Then what happened? They cancelled the allotment?
Hello?
They cancelled the allotment. What happened to the plot?
Yes, my lord. After allotting the plot to me, there was a dispute in respect of the property that was collected by the society for the catering of the property, making into bids. And in that regard, the original owner of the property approached the civil court in Raichoti, claiming that he wants to have more amount than the amount paid to him by the society. So this dispute was pending before the civil court from 1981 to 1993. So during this time, no registrations were effected by the society on behalf of the society and general body and managing committee. Now this appellant, Mr. Prabhakar Reddy, paid the entire amount having the membership number 142, 144, and having paid the entire amount, waited for the registration of the plot in his favor till 1993. because when it was pending before the Honorable Court, Civil Court, it was not possible for the members to get it registered because it was a matter of enhancement of the price of the land acquired by the society from the private owner. Now, in that aspect, in 1989, this respondent, who was not a member of the society, according to the president of the society, Mr. Y. Ramachandra.
This Lakshmi Manohar.
Lakshmi Manohar is the son of Lakshmi Narayana, and in favor of Lakshmi Manohar, the property was gifted by the respondent Lakshmi Narayana, and he is one of the respondents because he got gifted it from his father. Now here also, my lord, I submit.
So what happened? So there was a plot allotted to you by the society.
By the society.
It was not registered because the owner of the land had raised some dispute. He has not been paid enough money as
Yes.
compensation by the society.
Yes, my lord.
Now therefore your name was not registered.
Yes.
Now thereafter Lakshmi Narayana comes in.
Yes.
Now he gets allotted a plot? Same
No,
plot?
he was not got allotted by the society, my lord.
Then what happened?
Now, in 1989, when the dispute was pending before the civil court, this Lakshmi Narayana unauthorizedly got sold it from the president of the society, who was not authorized to effect any kind of registration. He has no power
In
to...
regard to the same plot which was allotted to you?
Same plot allotted to me, number 31. He has no any authority either to cancel or to transfer or to allot this, because if the president is part of the managing committee, when he is outside the committee, he has no any power. When he sails along with this society, he has got powers to execute on the recommendations of the managing committee. But here, this person has no any locus standi to transfer to register this plot that was already stands in the name of the appellant Mr. Prabhakar Reddy, unauthorizedly, without any kind of authority either from the general body or from the executive. He effected the registration on his own accord, and there is no any locus standi for him to register it, and he is, this respondent Lakshmi Narayana is not entitled to have that property getting registered through the unauthorized person. So when this the facts stood like this, in 1993, now when after the dispute, Mr. Prabhakar Reddy approached the society for the registration of the land that was site allotted to him in 1982, saying that he has paid the entire consideration towards the plot. Then there was a kind of a rumor in the town that it was registered in the favor of Lakshmi Narayana by the president without the permission of the general body or the executive committee. So in that regard, now this appellant obtained a encumbrance certificate from the registrar of the local registration, and then he came to know that this plot was registered unauthorizedly by this society president, who has no any power to effect it in favor of Lakshmi Narayana. Then this within limitation.
So one second. So now, so when the plot was registered in favor of Lakshmi Narayana, you went before whom?
To arbitrator.
Okay. So what happened there?
No, this arbitrator was very kind enough to accept the entire case of Mr. Prabhakar Reddy, saying that he is a member of the society with 144 general number, and he has paid the entire cost, and he is entitled to have this property, but...
No, but... no, but who was the fourth respondent? Deputy Registrar dismissed your application. He dismissed your application.
No, not rejected on merit.
Remand. So let us see. Fourth respondent dismissed the application, agreed with the said order. Number 2 approached the cooperative tribunal, remanded the matter for fresh adjudication. Fourth respondent took up the case again, dismissed the arbitration case. Second respondent filed an appeal against the order before the tribunal. Same was numbered. This appeal was transferred to cooperative tribunal number. Andhra Pradesh cooperative tribunal. Andhra Pradesh tribunal allowed the appeal against the order. And the project was verified. Second respondent, it was necessary to notice. Second respondent had not challenged the exceeding the suit in favor of the petitioner. And the matter was pending before the arbitrator. No, 1 second. So, you could not have raised any such dispute because it was not a dispute which could have been otherwise raised before the arbitrator, inasmuch as it was not a dispute concerning touching the constitution or management of the society. That is the crux of the matter.
No,
So the issue as to whether the allotment made in favor of Lakshmi Narayana was a good allotment or not, whether the sale deed could have been executed or not, could have been raised only before the civil court, and it did not touch the constitutional management of the society, and therefore you could not have gone to the arbitrator at all. That is the issue. So you have to satisfy us on that.
my submission, Your Honor.
And there is a division bench judgment which has been relied upon by the learned single judge.
My submission, my lord. This arbitrator,
No, this is a limited issue that in Venkat Ramana versus AP Cooperative Tribunal, Hyderabad, it was held that provisions of 61 of the Act would not be applicable to decide genuineness or otherwise of sale deeds and for cancellation of sale deeds. This relief you had sought not before the arbitrator in any case. You had sought it by way of an interim application before the tribunal, it appears. Is that so?
They invoked section 61.
before the tribunal,
Before the tribunal.
Before the tribunal.
before the tribunal, it would,
So now the issue is whether such a dispute could have at all been raised before the tribunal.
because this matter pertains to the registrar of cooperative societies, because it is a matter touching, comes under 61, Your Honor.
Let us see 61.
61 of Cooperative Societies Act. And further, being a non-member of the society,
So why don't you go before the civil court?
Now-
Can we go through this judgment? This, there are two judgments.
I passed on, my lord, in the last
B.
occasion.
Shravan Kumar and M. Venkat Ramana. Both these judgments?
Yes, I passed on, my lord, Venkatramana judgment. This is, my lord, Shravan Kumar judgment.
So you have to assist us on this then. How do you overcome these two? What do they say and how do you overcome?
now I overcome this point, Your Honor, Mayor. It is not a matter that the judgments that are being filed on behalf of Lakshminarayana are not pertaining to the land that is being presented before the Honorable Court, because that is the land that is pointed out in this order is exclusively meant for public, and the society was at liberty to sell it to anybody, and the society, nobody can question the society, because it was specifically meant for the allocation for private persons and for the business of the society. Whereas my case is
take us through the judgment and let us see how do you distinguish them?
my case is entirely a residential a plot related to residential purpose, Your Honor. That's why there is no any coordination between my claim and the judgment that is being presented by the Lakshminarayana, because the property that is incorporated in the judgment belongs to the general category, and it can be assigned by the society to anybody for its business purpose, whereas my property belongs to exclusively residential purpose, and this society, it comes under the registrar of the societies. That's why this dispute comes entirely under section 61 of Cooperative Societies Act. Further, my lord, I submit that this Lakshminarayana was not a member of the society till 2000, my lord. When he is not a member of the society till 2000, he is not entitled for any benefit, and moreover, fraudulently he got this judgment. Now, I rely upon this judgment, Your Honor, that has been submitted before the Honorable Court on third, judgment number 2, Your Honor, serial number 2. Now,
This is
Exertolls Limited and managing agent.
this is
I filed all these citations before the Honorable Court on 3rd of this month, Your Honor.
you give a copy of the judgment you are citing. Which judgment? You are citing this Shravan Kumar's judgment?
Citations, Your Honor.
What is the judgment you are reading?
A non-member he is not entitled to any plot, and when he got fraudulently registered sale deed, and it is not proper on the part of the aggrieved party to approach any court, because the property has been fraudulently got, and a fraudulent the person who resorted to fraud is not entitled to any kind of benefit. So in that judgment I filed that there is a Lakshminarayana is not entitled for any benefit out of this fraud. So being a non-member,
where do we see the ratio of the judgment? What is the ratio of this judgment? What is the ratio of this judgment you are citing?
the issue of the judgment is that a non-member is not entitled for any.
So please read, tell us where do we find the ratio?
Page number 5 to 6 run.
Please take us, where do you want us to read? Where do you want us to read from?
In that judgment, which paragraph you want to rely? You are citing some citation.
So
Which paragraph you want to rely?
5 and 6 even.
Para 5.
5 and 6.
What is section 51 of the Cooperative Societies Act? This was so we don't know what was section 51 of the Cooperative Societies Act which was applicable
It relates
there.
to 61 of them.
Huh?
It relates to 61 of
We don't know. So what does 51 say?
When it was in the combined state in Andhra Pradesh, then it was passed in 51, and this 51 relates to 61 in the present Andhra Pradesh Cooperative Societies Act. Section may be different, but the contents are one and the same.
1 of the said act, it says. So when you say says. So what do you want to, I mean, we have not read the whole judgment. What do you want to say? What is your argument?
My argument, my lord, he is not a member of the society.
No,
At
so-
that, I mean,
So this person who's being discussed in the judgment was not a member of the society?
he is not the member of the society at that relevant time, and he is not at the last, in the last paragraph.
So the court said that this needs to be investigated whether he was a member or not.
He was not a member of it.
So finally
and
the court
as a-
says, the court held that this needs to be investigated.
And then in the last paragraph, he is not, if it is found that he is not a member of the society at the relevant time, he is not entitled for any benefit. So that is the crux of the judgment.
Oh, that is all right, but whether such a dispute can be entertained at all, that is what I am saying.
It cannot be, because he is a non-member, that dispute cannot be decided. Because he is as a non-member.
If he is not a member, then certainly it can't be, you can't file proceedings against the said person. This is what the court says. What is the argument?
Yes, even if he is a member later on, this fraud remains as a fraud and it can be diluted. That is the spirit of the judgment, my lord. Let him become the member. It is immaterial.
The judgment you are relying now is related to the Madras Cooperative Society.
Yes, sir.
How that section 51 is applicable to our state?
It is a combined state, Your Honor.
No, this is Madras. This is Madras state.
Madras state, when it was in Madras, because this Andhra Pradesh has been bifurcated
That's
from...
all right, but see, the question is, we are confronted with these two judgments from Andhra Pradesh, division bench judgments.
The contents of 51 and 62 are one and the same, my
Can
lord.
we come to this DB judgment? Venkat Raman versus AP
So this,
Cooperative.
I submit, my lord, this Venkatramana,
DB judgment.
judgment of Venkatramana is not related to this case, my lord. Why? Because the society segregates the property that is being acquired for the benefit of the members or for the business. When the property is devolved into, separated into dwelling sites, and the common purpose is for temples or
Please
shops.
take us to the judgment. We have to make a beginning somewhere. Read the judgment, take us to the facts of the judgment. Finally, we have to, you see, say something. So please distinguish this judgment. Do you have this Venkatraman's case?
Venkatramana case, my lord, it now para 12, my lord.
something which touches the business of the society. What is this society? Why is the society incorporated?
But society, the facts
What
are
is the
like
purpose of incorporating the society?
incorporation of the societies for the purpose of acquiring lands and distributing to the members for the purpose of construction of houses. It is society name is NGOs Housing Society.
Yes.
It purchased large extent of land. It taken membership, and basing on the membership, it allotted lands and registered in the names of the members. The writ petitioner, who is appellant before appellant before his case is that long back in 1981 or 82, he paid 1 or 2 or 3 installments.
No, maybe. Now the question is the purpose for incorporating the society is to acquire land and distribute.
Yes, yes.
Now, if there is some dispute with regard to distribution of the land amongst the members,
Yes.
why can't it be a dispute touching the business of the society and therefore arbitrable? Why not?
Yes, the prayer, that is the reason, what is the prayer, prayed by him before the section 61 dispute
That is, we'll come to that.
Yes.
Now, the learned single judge has taken the plea.
Yes.
Or has taken a stand that, look here, because the dispute is with regard to alienation of a parcel of land in favor of Lakshmi Narayana.
Yes.
Therefore, this is not a matter which is falling within the scope of
Section
disputes
61.
which would have been referable.
Yes, yes.
How do you justify that?
The business of the society, with regard to day-to-day affairs of the society, any resolutions passed, that alone can be decided by the registrar. Not with registration of with regard to cancellation of sale deed. The prayer which he sought is cancellation of sale deed and recovery of possession, which was the prayer before the tribunal, which was granted by the tribunal. It is beyond the scope of section 61.
So sale deed cannot be cancelled
by the registrars under section 61.
It is not cancelled, Your Honor. It is set aside. Cancellation is different from setting aside, because cancellation has got ending of the judgment, whereas set aside has got still life to proceed. And here the cooperative tribunal said, Vijayawada said that he directed the society to get this plot registered in the name of Prabhakar Reddy, the appellant, and further directed that it can be set aside. The orders
the
of
learned single judge says that the tribunal would have no jurisdiction to set aside a registered sale deed. That is the point.
Because my submission, my lord, this is the property that comes under the dispute in section 61, because
See, assuming that you succeed, how would a registered sale deed get set aside? A deed which is registered. Which is the registering authority?
Sub-registrar.
Sub-registrar.
I submit to Your Honor. It is, my submission right from the beginning is, it is a fraudulent document.
Even if it is a fraudulent document.
Fraudulent document.
So you have to challenge it before a civil court only. We may not find anything.
No. My submission, Your Honor, it is a fraudulent document because.
Maybe, therefore you have to go to the civil court. I think the view expressed by the learned single judge is difficult to.
Kindly post it on 4th of next month.
Sorry.
4th of next month.
Okay, this is dismissed. Next. Yes.
Item 44 to 47, will be taken out.
Give these judgments. Item
44 to 47.
My Lord, in these matters, my Lord, I am appearing for my Lord appellants. My Lord, I recently appointed as standing counsel.
Okay, seek some time to go through papers, as the counsel has been engaged and recently. Yes, next.
Item 48, P. Kamalakar.
3 weeks. Item?
I am appearing for the appellant, Your Lordship, P. Kamalakar. He is held up before the other court, Your Lordship. Pass over may be granted.
Okay, passed over.
Obliged, Your Lordship.
49, Jawahar Chandra.
So very happy for the respondents, my lordship. I seek time for filing counter in this matter.
Item 49. Oh, this is a writ appeal. 49. Oh, this is a writ petition.
Writ petition.
You have not filed your response?
No, my lordship.
Okay, six time okay, none for the petitioner. So 6 time to file counter, 4 weeks, 6 weeks. Interim directions to continue. Yes.
50 and 51 in the Bharat Babu.
My lord, I am representing petitioner counsel, my lord. In this matter, counters are required, my lord. Counters are required in this matter, my lord. It is coming up for counters, my lord.
Any interim directions are issued?
No, my lord.
Okay.
The second matter, interim direction is there, my lord.
Okay, 51 interim directions to continue. Next, 8 weeks.
A pleasure.
Item 52, T. Koteswara.
My lord, I am online. My lord, I am for the petitions for 52 and 53. My lord, it is coming for counter. People, I mean, officers before your lordship is they are the SC gentlemen and disabled officers, my lord. They were respondents are to file their counters in the first week of June, my lord, still yet to be filed.
My lord, I request time for filing counter in this matter also, my
Last
lordship.
opportunity for filing counter, failing which cost shall be imposed. Cost of rupees 10,000 shall be imposed. 4 weeks. Next.
No pleasure, my lord.
Item number 54, Agal Keshan.
Your Lordship, I am appearing online, Your Lordship, may be permitted. The counters have been received, Your Lordship. I will be filing rejoinder, Your Lordship. 2 weeks, Your Lordship.
Okay, 6
Rejoinder, I
weeks
will.
to file rejoinder to the counter
Yes, Your Lordship.
affidavit. 4 weeks. Next. Any interim directions?
It's all,
No interim direction.
there's an interim direction.
There are interim directions?
Interim direction, but however, that became infectious, my lords.
All right.
Now, the main GO is under challenge.
Okay. Yes. 4 weeks.
Item 56, M. Srinath Reddy.
I appeal for the respondent's minute, I file my counter.
You have already filed?
Yes.
For whom?
For respondents, 1 and 2 minutes.
Respondents 1 and 2.
Yes, ma'am.
I'm appearing for the petitioner bank, my lord.
You are for the bank.
Yes, my lord. I may be permitted to argue online.
Yes, certainly.
My lord, this WP is.
Yes, what is this?
This WP is filed against the challenging the sale notice issued by the second respondent against my mortgaged properties, my lord. I am the bank, my lord, secure creditor. My lord, third respondent is a firm, my lord, engaged in the business of process of paddy and into raw and boiled rice mill, having a partnership firm. Managing partner 5 and 6 are the partners and other partners are there, my lord. And they approached the Bench Circle branch, Vijayawada and Nellore branch, my lord, and availed various credit facilities from the 2014, my lord. And the property under sale, my lord, subject property which was mortgaged to the bank for availing credit facilities for the security, my lord, P4, my lord, page 50 to 55, my lord. Memorandum of deposit of title deed. Totally they are availed 26 crores, my lord.
Okay.
24 later on another limit for total 45 fresh term loan. Like that they availed and they have become defaulted, my lord. Then the bank has filed OA, my lord. It was decreed, my lord, on 22/7/2020 at page number 78, my lord, lordship. P6.
78, Millard, Lordship's got.
Yes,
It was decreed, Millard. Yes, Millard. Later, the recovery certificate was issued and the Form 16 was also issued by, in pursuance of the decree, by the recovery officer of the tribunal, Millard, page 84, Millard, wherein our 34 properties was under attachment under RDB Act, Millard.
yes.
And the bank is also simultaneously issued a demand notice, Millard, which found at page in 2018, Millard, page 56, Millard.
Yes.
Here, Millard, coming to this point, this Millard, the rice mill against which the tax was due was built originally from the funds of the secured creditor, from our bank, Millard. And he was defaulted to pay. He was also defaulted to pay the, I think so, Millard, tax dues. But my contention is that, Millard, after 2016, the act was amended, both the SURFACI as well as the RDBI Act. As per the RDBI Act, section 31B, Millard,
Acts, both.
31B, in my petition also I mentioned, Millard, 31B says, Millard, priority to secured creditors.
RDB Act, RDB Act.
RDBI Act.
Page 24 of the writ petition, Millard, it is mentioned. It is extracted.
Section 31,
B of the RDBI Act.
31(3).
Yeah, 31B, Millard, which says priority to secured creditors, notwithstanding anything contained in any other law for the time being in force, the right of the secured creditor to realize secured debts due and payable to them by sale of assets over which a security interest is created shall have priority and shall be paid in priority over all other debts and government dues, including revenues, taxes, ceases, and the rates due to the central government or the state government or local authority.
What prevents you from proceeding further? What prevents
Millard,
you from...
I am not. I am asking the second respondent not to proceed against my property. Let them realize their dues, because here, Millard, the borrowers are liable to pay 120 crores and the property's worth is only 34 crores total, my scope. And if the matter, Millard, in this, kindly see, Millard.
How are they preventing you from proceeding to recover the amount against the properties?
They are not preventing, Millard, but they are simultaneously going against my properties, mortgaged properties, and they don't have a rights.
So what are they doing? What have they done?
They are issued shell notice, Millard. I am challenged. Page number, Millard, 134, Millard. And not only one, Millard, they are continuously, whenever the sale is failed, are continuously going, and that is also, Millard, they have putting the property for sale, which was worth of rupees as per my valuation, Millard. It comes under 1 crore 26 lakhs. Millard, as the Lordship knows, the secured creditor valuation, the provisions, the law, which for valuation of the property is taking into consideration of the market factors and all that thing. But as for the state and the civil courts, they followed only the SRO value, Millard. Actually, the value can be taken into consideration by taking into the market conditions, and the valuation can be fixed properly by the these secured creditor, Millard, compared to this one, Millard. In this one, actually our market value of the property comes to 126 lakhs, but they was going to sell that said property for 39 lakhs 89,057 against their dues of only 29 lakhs 89,000. What we are telling, Millard?
What is the amount? What is the amount due to the department?
Department due amount is, Millard, 29 lakhs 89,000 55,000 89,000 55 lakhs 55,000, Millard.
No, according to 134, 28 lakh 93,000. 270. Yes.
Yes, my lord, sorry,
And
sorry.
the
my lord.
property is worth about 33 crores.
No, no, property is worth, this property is the single property which was put for sale is subject property 1 crore 26 lakhs, my
Where
lord.
is that sale notice?
My lord, sale notice is found at page number, my lord, 157, my lord.
So how do you overcome this 31B?
It's, Lordship may kindly appreciate me.
No, how do you overcome 31B?
The assessment order, Millard, for the periods 2015 to 2019 was passed, Millard, on 31/12/2019. Millard, whereas, Millard, the OA filed by the bank was of the year, Millard, 2020, which was decreed, Millard, on 22nd July 2022.
No, when was the property mortgaged?
2014.
So,
Millard, that is what my difficulty. Millard, there are about, Millard, 18 properties, Millard, with mortgage, Millard, in favor of the bank.
maybe.
Millard, we are only proceeding against one property. And Millard, they can as well proceed, Millard, in
In one only surrender. Pass the judgment. Pass.
So there must be other
Millard?
properties
Yes, even
which are
Millard,
not
according to-
mortgaged.
Millard.
You can proceed against those properties.
No, my submission is, Millard,
Millard, in this I would like to bring honorable kind attention, Millard. All the 30 properties are worth only 34 crores,
We are
even
not-
our valuation.
We are not on that. So any property which is mortgaged as a secured asset with you, your bank, they cannot proceed in terms of
Yes.
31B.
Yes,
To
Millard.
that extent,
26A and 31.
Millard, there are no other properties left over, Millard, is my
so what to
submission.
do? How do you overcome 31B then?
Millard, it's a settled law,
Millard,
Millard, that Honorable Supreme Court also held, Millard, that once a
Millard,
secured creditor is always a secured
I am
creditor.
passing the.
And Millard, any dues, Millard, to the state or central government also, Millard, will take back seat.
So
That I'm not disputing
passing
it,
the
it is settled law.
That is the express provision.
I am passing
Yes.
the judgment of this lordship, Millard. I am passing the judgment, Millard, my colleague. Millard, judgment and the batch matters. This honorable court has already passed the judgment on 18th February 2021, Millard, between State Bank of India versus Deputy Commercial Tax Officer, Commissioner in Visakhapatnam, Millard. Wherein, Millard, para number 2, Millard, this honorable court judgment, Millard.
In fact,
Where is
I
it?
have paid in this matter, Millard.
Yes, Millard. Against this, there is now not preferred anything, Millard. And from 2016, Millard, the securicator is powered under Section 26E of Securitization Act and 31B of that one Act, Millard. Second para, Millard. The sum and substance of the stance of the petitioners in all these petitions is that in view of the provisions of Section 26E of Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act 2002 and Section 31B of the Recovery of Debts and Bankruptcy Act 1993, the debts advanced by the bank's financial institutions do have precedence over all the revenue dues to the central or state governments. In order to adjudicate the said issue, it would be appropriate to refer the said provisions of law which read as under 26E of the Surface Act. Priority to the securicator, Millard, same, notwithstanding anything contained in any other law for the time being in force after the registration of security interest, the debts due to any secured creditor shall be paid in priority over all other debts and all revenues, taxes, fees, and other rates payable to the central or state, Millard, or local authority. Section 31B, same, Millard, priority to securitators, notwithstanding anything contained in any other law for the time being in force, the rights of securitators to realize secured debts due and payable to them by sale of assets over which a security interest is created shall have the priority and shall be paid in priority over all other debts and government dues, including revenue, taxes, seizures, and rates due to central government, state, or local authority. The Millard, para third, Millard, the only objective contention raised by the learned government pleader, Shaker, Mr., is that since above mentioned provisions came into force with effect from 26/12/2016, Millard, that is, the said provisions are required to be enforced only in the cases where there is a creation of security interest posterior to the state debts. In fact, the said issued in present batch petition, which was also set aside, Willard, is no longer in regard, because in WP 23620 of 2017, while dealing the provisions of 26E, it was dealt, Millard, in that, where it was come to the conclusion, Millard, that on 1/9/2006, both the acts are special acts, these are amended, and 26E under Surface Act and 31B of the RDBA Act brought into existence, Millard, and shall be paid in priority to over all other debts and taxes and rates so and so. The debt due in the present case is the income tax payable by the 8th respondent to the Union of India, and Section 20C Surface Act gives priority in payment of the debts of a securicator over other dues, including the taxes payable to the Union of India. The attachment notice is liable to be and is accordingly set aside. Needless to say that on the sale of the subject property, if any amount is available after the entire loan of the borrower with interest and other charges are satisfied, it shall be made available to the Deputy Commissioner Income Tax for its adjustment to the income tax dues of the 8th respondent. The writ petition is accordingly disposed of, Millard. Another division bench of this court is in identical 5th para, Millard. There also set out circumstances allowed WP. Main thing is, Millard.
So what is the provision under which you have the power to sell the property after attachment?
It's under Section 26 of the VAT Act, Millets.
Can we see that? Does your notice of sale say that? Does your notice of sale say that?
No, Millets. It is under Revenue Recovery Act, Millets. We have preferential claim, Millet, over all other dues under Section 26 of the VAT Act. Section 28, Millet, gives power, Millet, to the Deputy Assistant Commissioner to proceed, Millet, with the auction. Section 26 minutes, you will watch me kindly see.
Section 26 of the VAT Act.
Yes, please. VAT Act. It's Section 26 minute, preferential claim to assets. The section starts with non-obstante clause. Notwithstanding anything to the contrary contained in any law for the time being in force, any amount of tax, including deferred tax, which is treated as a loan extended by the government to the dealer, penalty, interest, and any other sum payable by a VAT dealer or a tot dealer or any other dealer under the Act shall be the first charge on the property of the VAT dealer or tot dealer or any other dealer, as the case may be. This Section 26C, Millet, for the first time was introduced by way of an amendment in the year 2016, and it was gazetted, Millet, in the year 2020. Whereas the dues, Millet, by the third respondent is, Millet, for the year 2015 to 19.
This is a state act.
This is a state act. My submission is, Millet, Section 26C was introduced for the first time in the year 2016, whereas this Act, Millet, has come into force in the year 2005 itself. And, Millet, the period for which, Millet, the assessment order was passed, Millet, was of the years, Millet, 2015 to 19. So, therefore, Millet, by then, Millet, this provision was not there. So, Millet, the bank would not have, Millet, it was already negatived, Millet, by this court.
So, we'll pass orders.
Millet, my only submission is, Millet, that once a mortgage is always a mortgage, but it will come into effect, Millet, as on the date when it was.
Once a tenant is always a tenant, and once a mortgage is always a mortgage.
The movement, Millet, it is declared as NPA. Millet is got, Millet, relevance, Millet, is my submission.
Okay. Next.
I'm obliged.
May it please Lordships, I am Sheikh Jan Shaida appearing on behalf of the Senior Advocate MD Sharifuddin in this matter. I kindly request I kindly, respectfully seek an adjournment 1 week. Please request my lordship.
Okay, adjournment request, 4 weeks. Next. Yes, sir. Pray this honorable court to grant some time, lordships, to enable us to file counter. Meetings be complete. Obliged. Obliged. 8 weeks.
Item 50, sir. Rahul Yadav.
I beg to represent Mr. Tagore, my lord. It's coming up for filing of counters, my lord, by the respondents.
This is the third respondent request time for filing counter.
Meetings be completed, 6 weeks. Next.
Obliged.
Lordship, so please, my lord, kindly take up item 62 first, my lord, because it is filed first and I request item 62 may be taken up, my lord. Both are connected. Next item is filed first, my lord. The matter is not the petitioner before your lordship. Is a bank, my lord, and has the property of the sixth respondent is mortgaged to the bank. And after following the procedure under Surface Act, my lord, the bank has conducted auction on 12/7/2024. Lord, respondent number 5 is the, my lord, auction purchaser. After auction is conducted on 12/7, on 37, my lord, the first respondent, Directorate of Enforcement, has issued an attachment order over the same subject property under Prevention of Money Laundering Act. Lord, when we approached the, my lord, respondent numbers 2 to 4 for registering the property, Lord, they raised an objection on the ground that attachment order is there, it is placed under prohibition and it cannot be registered. Now, my lord, the imminent point for consideration for your lordships is, my lord, that we are prevented to receive the balance sale consideration to register the property. As your lordships knows, my lord, under Rule 9(4), time will lapse, my lord, by 90 days. But the two legal points, my lord, that falls for your lordship's kind consideration are: one, whether the under Prevention of Money Laundering Act, whether the first respondent is entitled to issue such an attachment order, in spite of, my lord, there is a security interest, as my lord, it is prior to the mortgage, prior to the attachment order, even auction is completed. The second important aspect for your lordship's kind consideration is, my lord, when there is such an attachment order by any authority, whether the state government has power, my lord, to stop registration under the Registration Act. Lord, Registration Act does not, my lord, give any such power to the registering authorities.
I am appearing for the first respondent, ma'am.
Has the response been filed?
No, ma'am, I want to file a response in this matter. I am for the first respondent appearing for this matter. The response, it's a conflict of laws, ma'am. The response is required in this matter, ma'am. We have to file a counter in this matter.
No, I'll make one submission, my lord, for your lordship's kind consideration. At this stage, my lord, what the best can, my lord, be done? May I request this, my lord? Lord, we'll receive the balance sale consideration in the register the property. We'll keep that amount, that, my lord, the balance sale consideration in a no lien account. My lord, it can be decided, my lord, after.
How does the your right to receive the balance lapse? Under the Act, beyond 90 days, you said it
Yes,
lapses? Under what provision?
And Rule 9(1) of, Rule 9 of, my lord, Surface Security Interest Rules.
Let us see.
Please see, my lord, Rule 9(4).
2002. Surface.
Yes, my lord. Security Interest Rules, my lord, rules appended to the Act.
Rule 9.
My lord. Rule 9, sub-rule 4. May I read, my lord? Rule 9, my lord, heading is time of sale, issue of sale certificate and delivery of possession, etc. Lordships got it. Sub-rule 4. The balance amount of purchase price payable shall be paid by the purchaser to the authorized officer on or before the 15th day of confirmation of sale of the movable property or such extended period as may be agreed upon in writing between the purchaser and the securitator, in any case not exceeding 3 months. But in this case, my lord, it is admittedly not extended up to 3 months, that is 90 days. That, my lord, the auction purchaser has filed this item 61 writ petition. He is asking, my lord, either to receive the balance sale consideration and to register the property or to refund the amount paid by him. Now, that will be causing, my lord, a loss to the public money. That is the reason for why I request, my lord.
You, now you want him to deposit.
Let him pay the amount. And
I was ready to deposit, my lord. What happened, my lord? I came to know.
How much is the amount which is to be
The
deposited?
2 crore 56 lakh is the remaining amount. I already paid 87 lakh.
All right. So
They
you
threatened
want him to
that I
pay
don't pay the
balance.
remaining amount. They will forfeit that.
Because
Wherein
if
I
you-
filed this.
If you do not pay, they will forfeit the amount.
They will forfeit the amount.
So then you want
My
the
request
balance
is,
to be.
yes, let them pay and we'll register the property. We'll keep that amount, my lord, in a no-lien account. This subject matter, my lord, decide.
So you let him pay. The issue of registration we will consider after objections are filed.
I clarify one second.
We will ask him to deposit so that that forfeiture is not hanging over.
So far as that aspect, I will satisfy one second, my lord. The properties with regard to the auction property is the proceeds of crime, my lord. It is not registerable, it's an auctionable property. It is not at all an auctionable property. Once Section 5 of the PML Act, once the property attached under the PML Act, it's come under the 71.
No rights will be created as
no,
rights will
it's
be
a proceeds of crime.
no rights will be created as such because the private party, the auction purchaser, runs the risk of getting his deposit forfeited. That is the problem. So we will ask him to deposit, and in case and the deposit will be subject to the outcome of the petition. If he fails, if you succeed, then we'll ask the bank to refund the entire amount with interest. No problem?
Action may pass over, I will get it instructions on that.
No problem. So it doesn't matter. We are not lifting your
Just I am
order of
submitting,
attachment.
just a minute, one submission, ma'am. There are two facets, ma'am. One the Surface Act, another is the PML Act. So far as the Surface Act is concerned, the revenue, debt, other things. So far as the prevention of money laundering is concerned, the proceeds of the crime. Whatever the property brought to the auction and sale, purchase, all that property is the proceeds of the crime. It will not permit to the executive sale unless and until
We are not saying, we are not issuing a direction to the registering authority to register the property. We are only taking care of the depositor's interest, the auction purchaser's interest. Lest his money 86 lakhs.
87 lakh. On previous occasion, I was protected with it. Till today.
Where is that order? In the first state petition.
Item
Let us see
61, my lord.
What is the order?
And the Supreme Court was pleased to direct, my lord, not to forfeit that amount.
Shall not be forfeited. So if he deposits the rest of the amount and if you lose ultimately.
In fact, they communicated to me, in fact, the bank.
What is the rate of interest that you will pay to him on 2 crores and 87 lakhs?
Whatever a fixed
2
deposit.
crore 56 lakh is the remaining amount.
Whatever the, my lord.
I already 2 crore 46 lakh in my account.
I agree with your lordship's, my lord, suggestion, my lord. Whatever the interest given on a fixed deposit in a bank, my lord, that will be applicable to them. We'll keep that amount in that account. But one submission, my lord, for your lordship's kind consideration is, my lord, so far as the legal aspect raised by my learned friend, it is settled, my lord, page 378 of my writ petition. The appellate tribunal, my lord, under PMLA Act, they themselves, my lord, they have stated, your lordships may so please may kindly see page 378.
We'll go to the merits, let him file his.
The same legal aspect, my lord, whether PMLA Act prevails over or, my lord, section 26C Surface Act will prevail.
Let him file his response and.
Meanwhile, please protect the interests of, my lord, the.
All right. Say so and so 6 and is granted 6 weeks time to file the counter affidavit. In the meantime, petitioner in writ petition number 22598/2024 is permitted to deposit the balance amount, how much?
2 crore 56 lakh.
Balance amount of 2 crore 56 lakhs.
Yes, Milord.
To the bank, which will be kept in a fixed deposit along with the money already deposited by him, representing the amount for the representing the auction amount.
2 crore 56 lakh 23,000.
Full stop. The deposit of the amount by the petitioner in petition number 22598/24 shall not be deemed to create any rights or equity in his favor, comma, and shall remain subject to the outcome of the present petitions, full stop. In case the petitioners do not succeed, comma, the amount shall be refunded to the petitioner in petition number 22598 along with interest, as has been agreed by the all right. Shall be returnable to the petitioner along with interest. Along with interest. Full stop. So we'll consider.
No, Your Lordship, not say, my lord, as I agreed.
All right. No, don't reflect that.
One submission, ma'am. So far this issue before the adjudicating authority, my lord. The pending, once the provisional attachment is ordered. Yes, ma'am. Yes, ma'am.
The aforementioned arrangement has been ordered with a view to prevent the forfeiture of the amount already deposited by the petitioner so-and-so in terms of section...
Rule 9(4). Rule 9, sub-rule 4.
In terms of Rule 9, sub-rule 4 of the Security Interest Rules of 2002. All right.
In this petition, the petitioners are challenging the rules amendment made to the rules. The ground that the conditions imposed, Section 15 of the main act, not compared with, that is placing the rules before the state assembly. As per Section 715 of the act, they should place before.
No, I have to file a counter in this matter.
Why are you not filing?
It has been very recently filed, minutes.
Okay, file your
File a
response.
Meanwhile, if they implemented these rules, it will adversely affect our interest.
Let us see
The clear
now you are
legal issue.
You are challenging a rule, they have to be given an opportunity. Yes, next.
That's true. The last occasion when this honorable court had.
6 weeks. Yes.
Your Lordship may kindly consider one aspect.
Yes.
Last occasion, other court heard this matter and posted today. As the I referred, I cited a judgment which is in favor, which says that without placing before the assembly shall not be implemented.
So we'll see. Let them file their response.
If the 6 months your Lordship adjourned, they become infructuous. If they implemented the rules,
okay,
it
let
will
them
become
file
infructuous.
your response. Okay, next. Who's in this?
Lord, I beg to represent Mr. Tagore, my lord. This matter is also coming for counter, my lord. There is an interim order granted by this honorable court.
So he was permitted to participate in the counseling process. What is this?
This matter in which Your Lordship, the PG, for the NEET PG, the cutoff date was taken as the date of notification. And assailing that an earlier writ petition was filed in which this Honorable Court has directed the petitioners to be permitted to participate, although they did not fit within the cutoff date. Thereafter, this writ petition was filed asking, seeking a direction, as was done last year, previous year, to restrict, to take those who come within the cutoff date as first priority, and those who fall beyond the cutoff date to be taken as the last candidates.
We have got the experience within the cutoff date, my lords. So therefore, my lord, we have requested, my lord, that we be considered.
No, so you were
We were
otherwise eligible to be considered and you had the experience.
Yes,
What
and
does
we
the
also applied, my lord, within the cutoff date.
What does the rule say?
Lord, within the cutoff date, my lord, we should be eligible, my lord, for being considered for PG admission in service quota.
So,
We were, my lord,
why were they preventing you from?
no, it is not that they were preventing us, my lord. What has happened in the other writ petition, a student, my lord, who was not within the cutoff date, who did not get the experience within the cutoff date, but 10 days later, my lord, he got the experience. Therefore, my lord, this honorable court granted an interim order that he also be considered in view of, my lord, the others.
That is the other petitioner.
Yes, my
That
lord.
is not before us today.
Not today, my lord.
So now what was your problem?
Our problem was, my lord, we are having experience, my lord, and we should be considered prior.
Why were
because
they not considering you if you were eligible otherwise?
Because, my lord, he is now entered into our the group, my lord.
So
Though
you
he
are-
doesn't have the experience,
So you are seeking,
the fourth respondent, my lord, should be considered only after, my lord, our cases are, my lord, first considered. Our candidature is considered. Lordship, may kindly see the interim order passed.
what is it? So what has this?
The candidates who are eligible, my lord, within the cutoff date.
Not within the council. So the order itself is clear.
Yes, my lord, order itself is clear.
Yes, so then you are the petitioner in this case?
Yes, my lord. Order itself is clear.
So which is the other petition?
My lord, other writ petition, my lord, is.
20919.
Yes, my lord. No, my lord. Writ petition number.
26833.
22147,
Yes, my lord.
page 84.
No, this was the controversy last year, in the last.
Last year, what happened
So
was, Your
now
Lordship,
also this is repeated?
what their plea is, the plea in the earlier writ petition this year was to requesting to extend the cutoff date, because they fall after 10 days, that writ petitioner. Now, this writ petitioner's claim is that we fall within the cutoff date, so if those who are falling after cutoff date are also permitted, we will be losing out on an opportunity, so let us be considered first.
So last year also.
Last year it was
we had
considered,
permitted
yes.
similar
They
arrangement.
were given the
So then what
preference.
remains? Who is the?
That
who are
was
the-
a different writ
So we
petition,
will
Your
list along with the other
Yes,
connected
Your Lord.
petitions.
Yes.
Where the interim directions have been passed. Which
There
are
are
those?
no connected writ petitions.
The other writ petition only is connected.
Other party, my
The
lord,
other
writ
party.
petitioner in other writ petition
Yes.
is not made as a party to this writ
No, he is a
petition.
party.
No,
Fourth
so
respondent is
who's
just
that petitioner in whose favor a direction had been passed to consider?
Page 84, my lord. Page 84.
Page 84. Is that still surviving, that petition? Is that still pending?
No.
No, that is
That was
disposed, my lord.
disposed of. This was passed on the 3rd of October, Your Lordship, and this present writ petition was filed on 4th of October.
4th of October. That writ petition was disposed of, my lord.
So then, so.
With this direction, this writ petition also can be closed.
No, but this may adversely affect the petitioner in the other petition.
So he was directed to be made a party.
So when? Where was that direction issued?
Lord, in the court, my lord, during the hearing itself, my lord,
Then
we have added him.
Have you done it?
My lord, yes, my lord. We have,
Where is-
my lord,
when did you?
during the court proceedings only, my lord, we have.
What is that? What is that?
We have added the fourth respondent
Oh,
as a
fourth
party, my lord, by.
respondent. Is he served?
No, no, my lord, notice has not been ordered.
So notice.
Yes, my lord. Notice may be ordered.
For service upon respondent number 4, personal notice is pending.
Obliged.
2 weeks.
But I beg to request my seniors, my lord, kindly post this matter 2 weeks, my lord, to file better for it, my lord.
What is this? 404 days. You want to file a better
Yes,
affidavit?
ma'am.
Seeks time to file a better affidavit to explain the delay. 4 weeks. Next.
I beg to represent the appellant counsel, Lordship. There is a delay of 7 days. My learned friend entered appearance. Lordship may kindly consider that.
7 days only.
7 days.
Say, we have gone through the application seeking condemnation of 7 days delay in preferring the present writ appeal for the reasons mentioned in the application and those urged at the time of hearing. The application is allowed, delay is condoned, post the matter for consideration. Yes.
The Lordship may kindly.
Next week?
Any date. There is enough.
2 weeks
This
maybe
week.
granted.
This week?
Yes. Any date, Lordship.
All right, Thursday.
Thursday.
My
Obliged.
lord, 2 weeks may be granted, my lord. We of, my lord,
So
I will
let us
file my
see.
counter also.
Obliged.
In writ
Obliged.
appeal, there is no counter required. Yes, next.
May I please, Your Lordship, so there is a petition to dispense with the filing order of the petition.
Dispense with is allowed. Yes. Next.
Obliged.
My please, there is a delay, my lord, 3 days.
3 days delay is condoned.
Much.
CNP is disposed of. This for consideration. Yes, next.
Item 16 and 77, CH Shivareddy, Chief of Land Acquisition, Vinod Reddy.
Lord, Mr. Shivareddy is appearing online, my lord, because he underwent surgery, could not travel.
The notice has to go, my lord, to respond number 6, 7 and 8, my lord.
What are these review petitions?
The review petitions, my lord, are against an order of this honorable court, my lord, wherein this honorable court was pleased to, my lord, allow the writ petitions. My lord, further there was a direction, my lord, to recover, my lord, the excess, the amounts paid, my lord, to the individuals who are not the assignees of the properties. My lord, that order, my lord, holding that, my lord, they were not made as a parties to the writ petition, my lord, a writ appeal was been filed. My lord, all the other matters, my lord, with regard to the very same issue, my lord, were allowed by this honorable court. And now, my lord, the petitioner, writ petitioner is no more. My lord, the respond number 6, 7 and 8 are the LRs. I initially appeared, my lord, for the writ petitioner, my lord, who was surviving.
No,
Now-
where is the order which is sought to be reviewed? Where is the order?
My lord, order is at page, my lord, page 11 is the order, my lord. The principal order is at page 15, my lord. Page 11 is the order in the present writ appeal. My lord, operative portion is at page 12 in the review petition.
No, 1 second. Where is the order? What is this, writ petition?
Writ petition, my lord. This was the review petition.
This is the Justice Prashant Kumar Mishra.
Page 12 is the order.
So you are appearing for?
Review petition.
For the review petition.
In fact, it's a powered order. Already your Lordship has given similar order in writ appeal. Same facts, my lord, but here it's a review because we have gone to Supreme Court and Supreme Court, it was, our counsel has agreed to file a review, my lord. Similar facts, my lord. Third parties, without notice to them, now they wanted to recover from them the compensation paid to them. They were not parties in the writ petition.
This was some writ appeal.
Yes, my lord, because in this case, the review petitions, they have filed an SLP before Supreme Court, my lord.
Huh?
They have filed SLP before Supreme Court, that is it, page 109, 1821, 109, my lord. There, our council has agreed to file a, he represented that they will file a review petition before this honorable. Accordingly, review is filed, my lord. It is at 109, my lord.
We have not understood.
No, this review petition.
There is a review petition filed before us. You say, what should we do with the review petition? Not hear the review petition.
Yes, my lord.
What do you say?
Notice has to, my lord, go to the LR's, my lord, that is respond number 6, 7 and 8. I appeared for the
One
petition.
second, notice has to go to whom?
6, 7 and 8.
Where are 6, 7 and 8 in the review petition? 6 is some Ramana.
Yes, my lord.
Only
Venkatramana.
one, there's only one. He is the LR of whose legal representative?
Review three is
Venkatramana was the original.
Review 3.
Venkatramana was the original petitioner.
My lord, original
Yes, my lord.
petitioner was M.
Yes, my lord.
M. Munemma, my lord. Settle out. M. Munemma was the original lead petitioner.
And this Madala Murugesh is the LR.
Is the third party and who filed the review petition?
Whose LR need to be brought on record?
Lord, LR is Chinna Venkataramanamma.
May I submit, my lord?
7th is Sanyasamma and Katamma, my lord, are the individuals, my lord, who are the LRs. That is 6, 7 and 8.
Sudhakar, who are the LRs of whom?
My lord, writ petitioner.
So writ petitioner is
May I submit, my lord?
Munnamma.
Yes, Munemma.
LRs are
Original writ petitioner. Yes.
So the original writ petitioner died.
Yes, my
Now
lord.
in the review LRs brought
LRs, they have made a party, my lord, whom notice has to go is the only requirement.
6, 7, 8.
Yes, my lord, sir.
Whereas 7th respondent Sanyasama is LR of R5. Not the writ petitioner. There are LRs of respondent number 5.
Here she is shown as
6,
a
7 and 8
respondent. She is the original, my lord, writ petitioner.
Oh, writ appellant.
Yes, my lord.
Am I audible, my lord? I am Siva Reddy, online.
One second.
Please, my lord.
This is filed by whom? This is by the.
Filed a third party, my lord.
You are for the district collector?
Original writ petitioner I am.
Who's for the, you are for the district
I'm the
collector?
district collector.
And the other appeal is by, who are the third parties?
Mary.
They are for the third
Your
party.
Lordship, peruse the docket order passed by Your Lordship
Yes,
on
Sanyasaya,
12th August.
Sushila,
In all the
and
years were
Jagannath.
mentioned.
Four.
So issue notice to respondents, 6, 7 and 8, in IE number.
May I submit, my lord?
6 of
Sorry,
2004.
sorry.
Yes. You tell us, yes. Yes.
Shall I, my lord?
Yes.
Obliged, my lord. This is the review petition filed by the third parties,
Filed by a
who are
third
the
party.
third parties in the writ petition. Writ petition was filed by one Munemma, my lord,
Yes.
claiming that she is the legal heir of the DKT Patta holder. And since DKT Patta holder has died, being the legal heir, she has filed the writ petition claiming the ex gratia as the said lands have been acquired by the government for the purpose of SEZ, my lord, Sri City. That is the basic contention. My humble submission is
Now the review petitioners were not parties before the writ court.
writ court, number one.
They were not parties.
They are not parties, my lord. That's why I have filed the leave petition. Altogether 7 petitions I have filed, my lord. One is the leave petition.
Where is the leave petition?
Leave petition, my lord, is IA number 1.
Leave to file review. No, but can you maintain a review petition if you are not a party in the proceedings?
Yeah, that's why I have asked for leave, my lord.
So
Because
you will have to satisfy us as to whether you can at all maintain such a
I,
review petition.
sure, my lord. The basic issue in this matter, my lord.
No, you have to satisfy us whether you can seek review of an order when you are not a party.
Yes, my lord. Because, shall I come to the facts of the case, my lord?
No, on a legal issue, whether a party was not a
Yeah, because I was
party
in
in the
the, yes, my lord.
proceedings.
Yes, my lord.
You may have a
I
right
was in
you
possession.
may have a right to
Ma-
challenge this an appeal after seeking
Exactly.
leave.
Yes, my lord.
You may have a right to challenge the order in appeal or in
Sure.
SLP.
Yes, my lord.
That's a different thing. But whether you can
Yes.
seek a review of the order if you are not
Yes,
a
my lord.
party. So you satisfy us on this legal ground. How do you
Basically, my
maintain
lord, I am the interested party in respect of the property acquired by the government, my
So
lord.
good, bad or ugly, judgment has been rendered.
Yes, my lord.
So
That
now you may have a good case that, look here, you had an interest, you should have been incorporated as a party respondent. The judgment has been rendered without incorporating you, without hearing you.
Yes.
You may have a good case. But to
Yes,
seek
my
a
lord.
review
Yes.
jurisdiction is exercisable in a slightly different perspective. Error apparent on the face of the record, etc.
Yes, my lord.
So how do you then
Yeah.
maintain
In
this?
fact, my lord, I have filed the SLP against the orders of this honorable court, my lord, in the writ petition. In the SLP, while going, arguments were on, then the petitioners have withdrawn that SLP with the leave of the Supreme Court to file the review here, my lord. So I have filed this review before this honorable court.
No, but still you are supposed to satisfy us whether review is
Yes.
at all maintainable. You may have withdrawn it, but tell
Yes,
us
my
how
lord.
a review is maintainable.
Review because I have been now asked by the revenue authorities to pay the ex gratia which has been paid to me in respect of this property, my lord.
No,
Since I have been,
we are asking you
I
to,
have
we are asking you to
the writ
satisfy us as to what is
yes, my
your right to maintain a review petition when you are not a party.
my humble submission is the demand has been made to against me to pay the ex gratia to the government in turn to pay to them.
That is on
Basically, the
merits.
writ
That is
petition,
on,
the
that is,
order of the
no,
writ petition,
that is on
one
merits.
submission, my lord.
That is on merits.
One submission, my lord. Basically, this writ petition order itself is not, it is non-est because the writ petitioner has died much earlier to the orders of this honorable court in the writ petition, my lord. This is non-est, and against the non-est order, they are demanding me to pay the amount, ex gratia. That's why I am interested in the writ petition. Hence, in the writ petition,
Shivareddy garu.
as I am interested,
Shivareddy garu.
I have been filed by the review petition, my lord.
Sir, Counsel Shivareddy garu.
Yes, my lord.
Please follow the question raised by the chief.
Yes.
Without there being any right to file a review petition by the parties who are not to the writ petition, how did you ask liberty before the Supreme Court? You have no right to file a review. You have a better case to file an appeal.
No.
Review is
One
not
submission, my lord.
maintainable where parties are not to the writ.
With the leave of the court, I am having the right, my
Supreme
lord.
Court never said that liberty was granted, but maintainability you should answer.
Yes, yes,
Supreme Court has given you permission to file a review. That does not mean that it has to be entertained. You have to satisfy this court how review is maintainable. Because scope of review is very limited. There is an apparent on the face, mistake apparent on the face
yes,
of the record.
yes, ma'am.
Error on the face of the record.
Error is,
Apparent on the face of the record.
yes, my lord.
So
Because by the,
you can't,
yes,
you
yes, yes,
have no, parties to the list only can file a review. The parties who are not to the list cannot ask for review. You can at most file an appeal. You have a better case for an appeal.
We give him an opportunity to prepare. Counsel for the
Satisfy.
Counsel, Mr. So-and-so shall address, seek to address us on the maintainability of the review petition. Now this leave is for filing the review? Leave to file the review. Counsel for the applicant, so-and-so shall address arguments on as regards the maintainability of the review petition in as much as the applicant was not a party respondent before, was not a party to the writ petition. Yes. 2 weeks. You please tell us.
Yes, I'll also oblige.
Appeal is okay.
Yes.
With leave you can, but we have our doubts. A review petition perhaps cannot be filed with leave.
I'll also.
At par with the application for leave to prefer an appeal.
Item 48, P. Kamlakar. P. Kamlakar.
Lordship, subject to my lord's kind, maybe
What
take
is- what
item
is
number
this?
48 may be taken up tomorrow.
This is 48?
This was
What is this about? Is the service complete? Is the service complete?
It's coming for paper publication.
Has it been published in the paper?
In fact, Your Lordship, I am not aware of that, Your Lordship.
No memo is served on this.
May be taken up tomorrow, Your Lordship. He will address the arguments.
Okay, tomorrow?
Tomorrow, Your Lordship.
Tomorrow as requested.
May it please, Your Lordship. Item number 66, Your Lordship, it appears this matter was item number 66. Your Lordship directed to put this matter on this Thursday or next Thursday. In fact, this Thursday my senior is not available, Your Lordship. It may be taken up on next Thursday, Your Lordship. I am appearing for the fifth respondent.
Okay, give some date. When is your senior available?
Next Thursday, Your Lordship.
Next Thursday. 66.
66.
Inform the other council.
Yes, Your Lordship, I inform.
For this Millard, item 52, 53 Millard, I could not present at the time of calling Millard, it's coming for counter not filed.
We'll pass some order, you can check. Is it here? So we'll come. Two cases.
May I please, Your Lordships? The petitioner before Your Lordships seeking time to grant time till 6/12/2024, Your Lordships. The presiding officer is on leave. My application for extension of time is pending before the DRT, Your Lordship. Originally, the petitioner is the auction purchaser, Your Lordships. He paid 25% of the bid amount. I filed the proceedings, page number 30 to 35, Your Lordships.
No, generally tell us. So, you are the auction purchaser?
Yes, Your
You deposited 25% within how many days?
Within the 15 days, I have, immediately I have deposited.
You have to deposit 25% within the next day?
Yes, Your
Next
Lordship.
working day?
Yes, Your Lordship.
You deposited that?
Yes, Your Lordship.
So rest you have to deposit within?
15 days, Your Lordship.
That you deposited?
No, Your Lordship, that is why I am seeking time.
No, can you seek time from the DRT? You may, with the consent of the financial institution, get the time extended up to 3 months, I think.
Yes, Your Lordship, 3
But
months, I
so
have filed IA.
How can the DRT extend time? How can we extend time? Tell us.
The amount was very huge, Your Lordship, 4 crores, remaining 4 crores I have.
But how do we extend time? We can't extend time. This has to operate, the provision has to operate. Take us to the relevant rules. Take us to the relevant rules. Rule 9(4).
9(4), Your Lordship. The security interest rules to 2002, Your Lordship.
So please read. You read 9(4). You have 9(4)? Why did you not bring the act and the rules with you? When you appear in a case, you should bring at least the act.
Sincere apology.
Have you mentioned in the petition the act and the rules?
I have mentioned it.
So, you should do justice with your client also. What is the relief that you seek?
I'm seeking time till 6/12, Your Lordships. The similar set of facts, Your Lordships, granted interim protections to the borrowers, Your Lordships. I filed the order copy, Your Lordships, along with the petition. And petition number 21513 of 2024, Your Lordship.
Okay, only notice. 2 weeks. Personal notice permitted.